you see judges in Supreme Court, right? Supreme Court being a constitutional court, Article 124 of Constitution of India deals with how the judges of Supreme Court has to be appointed. Similarly, Article 217 deals with appointment of judges into High Court. What does Article 124 says? Article 124 says Supreme Court judges are to be appointed by President of India. By whom? By President. But before doing so, he has to consult with Chief Justice of India and as many other judges of Supreme Court or High Court as he deems fit. So, appointment has to be done by President, but President before doing so has to consult mandatorily with CJI and other judges if he deems fit. Now, the word mentioned here is consultation, right? This word consultation, the interpretation of this word consultation has been done differently by Supreme Court in various of its cases. The matter was first taken up by Supreme Court in the year 1981 in a case which is famously called as First Judge case. Here Supreme Court said that the meaning of word consultation is merely exchange of views, right? The meaning of word consultation is merely exchange of views, meaning President will be taking consultation with CJI, but whatever CJI recommends, that is not binding on President of India. But Supreme Court in a later judgment in 1993, the case which is famously called as Second Judge case, reversed its position from First Judge case. Here Supreme Court said the meaning of word consultation is binding, right? So in First Judge case, it was only exchange of views. In Second Judge case, Supreme Court said it is binding on President of India, the consultation or recommendations made by CJI. Now, and second thing which was outcome of Second Judge case was that Supreme Court also said in order to reduce the discretionary power of CJI, now the recommendations will be given by a 3-member body. So, recommendation to President will not be given just by CJI, but a 3-member body consisting of Chief Justice of India and 2 senior most Supreme Court judges. Yes. So, and this 3-member body, this only is called as Collegium, right? So, Collegium, it is an innovation of Supreme Court. It is nowhere mentioned in Constitution of India, right? So, through Second Judge case, Collegium system came into being. The same, this article 124 or interpretation of word consultation, it was again challenged or it was again taken up by Supreme Court in the year 1998, which is very famously called as Third Judge case. Here Supreme Court first of all declare the Collegium system as constitutional. Second thing which Supreme Court did with Collegium system is Supreme Court expanded the size of the Collegium. Now Collegium was made of 5-member body, again consisting of Chief Justice of India and 4 senior most Supreme Court judges, right? So the Collegium system which we see now consisting of 5 members, it is an outcome of Third Judge case 1998. So that is how Collegium system it is working or functioning since 1998. Now similarly for High Court judges also we have a Collegium in High Court, and then the recommendations of High Court Collegium goes to a Supreme Court Collegium consisting of 3 members only, and then Supreme Court forwards that file to or makes the recommendation to Law Ministry. Law Ministry sends the same name to President of India. Yes, and then President has to appoint such a person as Judge of Supreme Court or High Court. We also have a case of 2015 which is sometimes called as Fourth Judge case. Here what Parliament did is, Parliament in 2015 amended the Constitution and brought an act, it is called as NJAC Act. NJAC Act meaning National Judicial Appointment Commission, NJAC Act. As per this act, what Parliament wanted was, Parliament said now the appointment to Supreme Court and High Court judge, for appointment we will be having a permanent commission. It will not be done by Collegium system, it will be doing it by a permanent commission, and this permanent commission will be consisting of 6 members. Out of these 6 members, 3 will be from Judiciary. 3 will be from Judiciary. 1 again will be Chief Justice of India and 2 Supreme Court judges. But rest 3 members, 1 will be Law Minister of India. Law Minister of India. And 2 will be eminent jurist appointed by President of India. So now this amendment, the NJC Act, this act was passed by almost full majority in both the houses of Parliament. But even then, the very next year, Supreme Court of India in 2016, they struck down this act, saying that there is a presence of executive law minister into NJC or this commission, which threatens the independence of judiciary, which it is violative of Article 50. Not Article 50, Article 50 deals with separation of power, but independence. So, independence of judiciary is threatened because of presence of Law Minister of India, and hence they struck down this act. This judgment, it is sometimes called as fourth judge case, which did not change Collegium, but they stopped or halted the change which was suggested by Parliament of India. So, this is about Collegium system. Now, Collegium system, it has some limitations. For example, it is criticized because of its opaque functioning, meaning the decisions which are taken by Collegium system, right, they are taken within a closed room, right? So what names the Collegium is considering, the names which Collegium is rejecting, or the names which Collegium is accepting to be appointed as judge of Supreme Court or High Court, the rationale behind those names, nothing is made public, right? So public or judges, they don't even know why their name was rejected by Collegium, why a particular person has been appointed as judge of Supreme Court or High Court. So its functioning was very opaque. The Collegium system, it is also sometimes criticized for nepotism. Nepotism, meaning there are many judges in Supreme Court and High Court whose relatives are already members of higher judiciary, right? So this charge is also leveled against Supreme Court or Collegium system. Collegium system, it is also criticized for not being able to ensure diversity in Supreme Court or High Courts, Supreme Court especially, meaning, for example, Supreme Court should maintain regional diversity. There should be judges from each and every part of India. So sometimes Supreme Court Collegium fails to ensure such kind of diversity. Supreme Court or the representation of women in Supreme Court is not up to the mark. The representation of vulnerable sections like SCs, STs, that is also not up to the mark. So Collegium, it is also criticized for not being able to maintain the diversity into Supreme Court. So because of these reasons, right, Supreme Court recently, it has thought of bringing some change into Collegium's functioning. For example, now they have said we will be interviewing judges. Secondly, we will exclude relatives. So we have discussed there are charges of nepotism against Collegium system. There are some other problems also with respect to Collegium. For example, the rules of the Collegium, they are not very fixed, meaning, so Collegium, it operates without formal and binding guidelines, right? So Supreme Court Collegium, it does not has very clear cut or crystal cut guidelines. It is not very formal organization. Secondly, there is lack of clear procedure with respect to Collegium's functioning. Now what happens because of it is, many a time Collegium makes recommendation to the government, but government stops some few names which government doesn't like. In the name of government, sometimes say कि this person is a threat to national security or integrity of the country, integrity of the nation. So sometimes national security, giving such grounds, national security, integrity of the nation, some names will be rejected by government which were recommended by Collegium. Now it creates a tussle between judiciary and executive, right? So this is also one limitation. Because of this, what happens is there will be influence of political class into judiciary. It makes the process of appointment very inefficient. There is high vacancy especially into high courts. Half of the strength of the high court judges is only 60% of the sanctioned strength. So right now 40% seats in high courts, they are vacant because Collegium system not been able to work properly. Now nepotism thing we have already discussed. Then implementation framework is not very proper, because of which again the judiciary, it suffers. Then there is lack of independence of judiciary or there is kind of again a mismatch or a tussle between government control over judiciary and judiciary's independence. So these are many problems with collegium system, and hence Supreme Court in 2015 itself recognized the collegium system, it has some flaws, but they said we can't allow NJAC like system. Reason being, in NJAC there is interference of government, and government being the biggest litigator in courts, right? If government itself will be having a role in appointment of judges, people will lose faith into judiciary, right? So giving these arguments in 2015, collegium system was upheld and NJAC was rejected. Now Supreme Court, these two measures which are in news, they are a effort or they are an initiative of Supreme Court in order to make collegium little more transparent, little to fight against the criticism of collegium system, right? So what is the way forward? Way forward is we have to reform collegium system, and we should be having respect for law, meaning the judgment given by Supreme Court is law of the land, right? If Supreme Court has said that collegium system is going to be there, or NJC system will not be replacing collegium system, the judgment of Supreme Court is law of the land. Government then should be adhering to whatever collegium says. The second is there should be collaboration for judicial integrity, meaning the meaningful reforms in the judicial appointment process will only succeed if judiciary as well as the government will collaborate. So judiciary, even though it has accepted the collegium system has some flaws, they should work for meaningful reforms. Along with executive, they should come up with the MOP, Memorandum of Procedure, which is agreeable to both judiciary as well as executive, so that collegium can function in an effective manner.